This matter of is for judgment. The judgment is ready. And it will be read shortly. This is the judgment of the court. The claimant instituted this suit on the 1st of August 2019 via a general form of complaint. In the complaint, the claimant sought against the defendant the following reliefs. They are: 1, a declaration that the conduct of the claimant in relation to the opening of account for Mechino Multipurpose Cooperative Society Limited was lawful and not constitute gross misconduct. 2, a declaration that the dismissal of the claimant's employment by the defendant on grounds of A, opening an account with incomplete documentation, B, failing to carry out know your customer KYC checks on the account, and C, aiding and abetting customer to defraud unsuspecting members of the public by a letter dated 24th day of May 2019 entitled dismissal is illegal, null and void, and of no effect whatsoever. 3, an order setting aside the defendant's letter dated 24th day of May 2019 entitled dismissal. 4, 190 million naira, 252,296 naira only for breach of contract with the defendant. 5, an order directing the defendant to forthwith compute and pay to the claimant all his salaries and emoluments from the date of his dismissal from the service of the defendant till judgment is given in this case. 10% interest per annum on the sum claim till judgment is given in this case. 7, 10% on the judgment sum till the judgment date is finally decreed. Upon being served with the originating process, commencing this suit, the defendant filed its statement of defense and counterclaim on the 3rd of September 2019. The claimant on the 2nd day of October 2019 filed a reply to the statement of defense and defense to the counterclaim. On the 15th day of February 2022, the claimant testified in proof of his case as CW1. CW1 identified his witness statements on oath and adopted same as his evidence in this case. Documents were tendered through CW1. They were admitted in evidence and accordingly marked as exhibit. CW1 was recalled when he tendered his payslip in evidence as exhibit CR1 and the certificate of compliance with section 584 of the Evidence Act as exhibit CR2. The case of the claimant, I shall skip reading the case of the claimant, so counsel will read it when they collect the hard copy. Then I also reproduce the summary of the defendant case. That one too, I will skip reading it. I go to the submissions of reply to the statement of defense and defense to counterclaim. That one too has been captured in the body of the judgment. We go to the submissions. The submissions of the defendant, Mr. Obande, formulated a single issue for determination. The argument of counsel on the issue has been reproduced in the body of the judgment, so I shall skip reading the argument. I proceed to the submissions of the counsel for the claimant, which where two issues were formulated. The argument on the two issues have been captured in the body of the judgment. There is also a reply on point of law filed by the defendant. The argument on the reply on point of law has also been captured in the body of the judgment. So I shall also skip reading it. I now go straight to the judgment of the court, the decision of the court, so as to save time. This is the court decision. I have considered the processes filed by the parties, the evidence laid, the final written addresses, the defendant's reply on point of law, and oral submissions canvassed by counsel in adumbrating the respective positions of their respective clients. In the final written address of the defendant, a single issue was formulated for resolution, while the counsel for the claimant submitted twin issues for resolution. The claimant's reliefs have been reproduced in the earlier part of this judgment. They are 7 in number. The first, second, and third reliefs. First, second, third, and fourth reliefs are the main reliefs being sought by the claimant in this matter, while the remaining are ancillary claims depending on the grants of the first, second, third, and fourth claims, fourth reliefs. In the case of Gabriel Atibi versus Kabel Metal, the Supreme Court has this to say regarding reliefs before the court. I quote, "The duty of a plaintiff therefore is to plead only such facts and materials as are necessary to sustain reliefs and adduce evidence to prove same. He may at the end of the day obtain all the reliefs claims or less. He never get more, nor does he obtain reliefs not claimed. A court is therefore bound only to the reliefs claim. It cannot grant reliefs not claimed. It is clear from the above quotation from the decisions of the Supreme Court that the law has always been that a claim is circumscribed by the reliefs being sought, and a claimant is only bound to adduce sufficient evidence in proof of his case. This means that this court is only bound to consider the reliefs presented by the court by the claimant, and the court has no duty to go outside the reliefs being sought, and the court cannot serve as per the Christmas dishing out unsolicited gifts. In this respect, the evidence and argument of counsel for the claimant on the alleged purported denial of fair hearing having been made without any reliefs claimed in that respect goes to no issue, as this court is duty bound to consider only the reliefs as claimed by the claimant. In so far as the reliefs claimed in this action are concerned, there is no reference whatsoever to any relief on fair hearing. A court cannot give a party a remedy he has not asked for. A court is bound by the relief sought by the parties. The charity or generosity of a court is confined strictly to the relief sought before it. It cannot give over and above what the party has claimed. In the circumstances of this case, the issue of fair hearing and lack of it canvassed by the defendant in the last lap of his submissions for purposes of this judgment are hereby discountenanced. The first two reliefs, in this case, the first two reliefs are for declarations. The law places heavy burden on the plaintiff to establish his declaratory reliefs to the satisfaction of the court, where he fails to establish his entitlement to the declarations by his own evidence, the reliefs will not be granted even on the admission of the defendant. See the case of Inakojo versus Adeleke. See also Attorney General of Cross River State and Attorney General of the Federation. See also the case of CPC versus INEC. Briefly, the facts that led to the institution of this case, as can be gleaned from the processes filed and the evidence laid in the course of the trial, are that the claimant by the Exhibit B was employed by the defendant on probation. at the end of the probation and after satisfying the requirement for confirmation, the appointment of the claimant was confirmed as per Exhibit C. The claimant as assistant manager and operation officer of Mary Seleso branch of the defendant on the 10th day of July 2018 opened an account for the society registered by the Registered Cooperative Society of the Federal Capital Territory, Abuja, as Cooperative Society, see Exhibit N, from 10th of July 2018, when the account was opened, to 21st day of August 2018, a period of 6 weeks. The account received a total inflow in the sum of 183,979,303 naira and 24 kobo. The judgment in the account, the lodgement in the account of the society with the defendant was transferred to another account of the society and 2 other individuals with GT Bank. On the 29th day of October 2018, a query was issued to the claimant on operation of the society's account, wherein certain irregularities regarding the opening of the account were pointed out, and the claimant was asked to explain the purpose of the account that generated inflow in the sum of over 183 million. The claimant was also asked to provide outstanding documentation missing in the documents used in opening of the account, see Exhibit B and Exhibit D3125. In his reply, as shown in Exhibit W and Exhibit D3125, the claimant stated that the society commenced banking business on the 10th of July 2018 as multi-purpose cooperative society, and accordingly, information gathered according to the information gathered during marketing drive, the main purpose of cooperative was for the estate development following the acquisition of large parcel of land from Adiabo community in Calabar, which was investigated and verified. The claimant further stated that the account was open to accommodate subscription, registration, and sundry payments of 120,000 naira by its members interested in real estate and property development, and all transfers according to signatories to the account was to their agent. The search report is still being expected, where the trustees' information would be provided. On the 27th day of November 2018, the claimant appeared before the disciplinary committee of the defendant regarding his role in the operation of the society's account with the key outstanding documentation. At the end of the hearing, the committee recommended dismissal of the claimant from service of the defendant. See Exhibit D3125, containing the disciplinary committee report. In line with the recommendation of the disciplinary committee, the claimant was dismissed from service of the defendant as per Exhibit T, letter dated 24th day of May 2019, after receipt of Exhibit D1 to 5. The claimant instituted this suit to challenge the validity of his dismissal from service of the defendant. According to the claimant, his dismissal was illegal, unlawful, null, and void. Before considering whether or not the claimant has succeeded in proving any of the reliefs being sought, I shall point out here that both parties, in their respective final written addresses, have interchangeably made references to termination and dismissal as one and the same thing. In our labor, let me say, in our labor jurisprudence, unlike in other claims, the two terms, termination and dismissal, have different connotations. They do not mean one and the same thing. There have been a plethora of authorities evincing subtle distinction between the two terms. See the case of CBN and another versus Mrs. Agnes M. Iguilo. See also the case of Alaji MK versus First Bank of Nigeria PLC and another. His Lordship Ogbunya JCA stated in that case, termination or dismissal of an employee by the employer translates into bringing his employment to an end. Under a termination of appointment, the employee enabled to receive the terminal benefit under the contract of employment. The right to terminate or bring an employment to an end is mutual, in that either may exercise it. Dismissal, on the other hand, is punitive, and depending on the contract of employment, very often entails a loss of terminal benefit. It also carries an unflattering opprobrium to the employee. End of quote. Termination in law is defined to mean an end termination defined time of existence. See Black's Law Dictionary, 6th edition, page 1471. This means a law of termination implies its end in time or existence or cessation of the rights and obligation arising, implies its end in time or existence or cessations of right or obligation arising from and under the contract. Dismissal, on the other hand, means to send away, particularly from one's employment or from service, to relieve from duty or to release or discharge from employment. Sometimes dismissal is the real sense, is described as summary dismissal, an expression defined by the court in the ACB versus in BCK as implying to relieve from duty or to release or to discharge from employment, usually done or given immediately without attention to details or formal procedure. In Calabar Cement Company versus Daniel, the Court of Appeal stated that it is settled practice that the two provisions for dismissal and termination of a contract of employment operates independently to each other. The celebrated case of Olanian University of Lagos present another illustration of this. What is clear is that legally both termination and dismissal all imply removal from a particular employment. However, the consequences may vary. It is interesting to point out that in Lasisi versus Allied Bank of Nigeria PLC, the Court of Appeal agreed that an employee who has a right to an employer who has the right to dismiss his employee could resort to the lesser punishment of termination. This shows clear distinction between the two terms. It is apparent from the above case laws that some basic distinction has been recognized as between termination and dismissal simpliciter in contract of employment that necessitates separate treatment of the doctrines of both principles. It can be deduced from the distinction that the right to terminate can be exercised by both parties to the contract of service, and when they do so, reasons need not to be given, while the power to dismiss can only be exercised by the employer, and in the exercise of that power, the employer must state his reason for doing so. Therein lies the basic distinction. Therein lies the bare distinctions from which some consequences flow in varied and varying forms. For instance, that means that the termination gives the parties the right to determine the contract at any time by giving prescribed period of notice, while dismissal, on the other hand, is disciplinary measure not entitling the affected staff to notice or benefit. The power to dismiss is power exercisable by the employer without a corresponding power in the servant. See the case of Calabar Cement Company Nigeria Limited versus Daniel Supra. See also Abo Meli versus Nigerian Railway Corporation. See also Adamo Balade versus Ijebu Ode. See also First Bank of Nigeria PLC versus Kenneth Imeka. In Daudu versus UBA PLC, the court agreed that employer can bring the appointment of his employee to an end for any reason or for no reason at all, so long as he acts within the terms of employment. His motives is irrelevant. However, if a reason is given for the termination or dismissal of an employee, the burden lies with the employer to justify the said reasons. See the cases of Kulle versus Osisen, Kulle Osisen versus Apribom Nigeria PLC, SPDC Limited versus Wala Rewaju, and Angel Shipping Dine Limited versus Aja. It is clear from the authorities cited above that distinction carries with it dismissal carries with it infamy and deprives the dismissed employee of benefits, while termination of employment does not. The employer is not bound to give any reason for lawful termination or lawfully terminating a contract of service. He must give reason for summarily dismissing the servant. In the instant case, the employer gave reason for summary dismissal. It is not as though it woke up one night and decided to dismiss the claimant. An extensive investigation into the act of misconduct was done, and the panel found the claimant wanting a recommended delegation. See the exhibit D315. See also the decision in the case of Ogunsami versus CF Furniture West Africa Company Limited. See also IREM versus Obubura District Council. In any event, the accepted general legal principle is that the employer has a general power to dismiss for misconduct of any kind that can justify dismissal, and to terminate the employee's employment or give him a month's notice in lieu of notice thereof, 1 month salary in lieu of notice thereof, where an employee is found to be engaged in dishonest practices or criminal activities or acts and behavior that demonstrably portray an employee as an unreliable person. The employer has very strong reason to dismiss an employee in such situation. In these kind of cases, the dismissal of an employee is usually attributable to acts of misconduct by which the employee had performed below the expectation of the employer or has allowed his pernicious behavior to make the employer suffer losses or exposes the employer to risk. See Abakumba versus Africa Timber and Plywood Limited. See also College of Medicine of University of Lagos versus Adebite. See also Hussein versus Bank of West Africa Limited. See also CCB Nigeria Limited versus Wanko, and Abomeli versus NRC Sufra. Therefore, an employee may be summarily dismissed without notice and without wages if he is guilty of gross misconduct. See Boston Deep Sea Fishing Company Limited versus Ansel. See Babatunde Ajayi versus Texaco, Nigeria Limited, and others. And gross misconduct has been identified as a conduct that is of grave and weighty character as to undermine the confidence which should exist between an employer and the employee. Likewise, working against the deep interest of the employer amount to gross misconduct, entitling an employer to summarily dismiss the employee. See the case of Olanye University of Lagos versus University of Lagos. A servant whose conduct has been such that it would be injurious to his master's business, such an employee has committed an act of amounting to misconduct warranting his dismissal. See the case of Maja versus Tako. See also the case of CCB Nigeria Limited versus Wanko. To warrant a summary dismissal, it is suffice such an employer has committed an act amounting to misconduct warranting his dismissal. See Maja versus Tako and CCB versus Wanko. Warrant a summary dismissal, it suffices that the conduct of the employee is of such grave and weighty character to undermine the relationships of confidence which should exist between the employer and employee. See the case of Taliet Sule versus Nigerian Cotton Board. See also the case of Eze versus Supreme Bank PLC. Taking into consideration the relief being sought by the claimant in this case, which borders on declarations that the conduct of claimant in relation to the opening of account for the society was lawful and not constitute gross misconduct, and therefore his dismissal is illegal, null and void, and of no effect whatsoever. Setting aside of letter of 24th day of May 2019 dismissing claimant from service and the monetary claim, it shows that the claimant is seeking for nullification of his dismissal. The claimant is also claiming payment of salaries and other entitlement from date of dismissal to judgment, as well as damages for breach of contract. By the decision in the case of ZD versus Rivers State Civil Service Commission, an employee who complains that his employment has not been properly determined has the onus to place before the court the terms and conditions of employment and prove in what manner the said terms were breached by the employer. The law is also tried that it is not the duty of the employer as a dependent to prove any of these facts. See also the case of Morufolo versus Kwara State College of Technology. See also Ningi versus First Bank of Nigeria PLC. See also Kato versus CBN. See also Adamu versus LPDC. See also Igbenobia versus University of Benin Teaching Hospital. See also Tugudaromo versus Goton. See also Okoibo versus Police Service Commission. In an attempt to prove his case, the claimant pleads before the court a number of documents. They include his letters of employment Exhibit B, confirmation Exhibit C, email forwarding accounts opened in July 2018 with outstanding regularization Exhibit D, the bylaw of Michenu Multipurpose Cooperative Society, Exhibit E, certificate of registration, Exhibit F, letter of passionate appeal, Exhibit G, email on passionate appeal, Exhibit H, Such report Exhibit I Coordinatory detail Exhibit L, board resolution Exhibit M, certificate of registration Exhibit M, other accounts opening documents Exhibit O, Q, and R. Official receipt Exhibit S, response to query Exhibit T dated May 24 is the letter by which the claimant was dismissed by Benin Bank, the defendant in this case. It is the claimant's. In it, the claimant was informed of his dismissal from the bank with immediate effect from the 24th day of May 2019. The date of the letter, the date from the date of the letter of dismissal. The dismissal of the claimant from service was predicated on A, opening an account with incomplete documentation, B, failing to carry KYC checks on the account, C, aiding and abetting the customer to defraud unsuspecting members of the public. It is clear from Exhibit T that the claimant was dismissed from the defendant's employment for misconduct. As pointed out earlier in this judgment, the concept of dismissal exposes the power originally and ostensibly extant common law power exercisable by the employer only usually as a disciplinary measure. A lawful dismissal implies a wrongful repudiation on part of the employee, which is deemed to determine the contract of service, entitling the employer to treat the contract as if as at an end and justifying the seeking of removal or dismissal of the employee. If the employer so wishes, for an employer to be entitled to so treat a contract of employment as at an end, of course, there must be deliberate fundamental breach of a provisions of the contract of employment or the employee's duties to the employer. Employee's duty to the employer. This means, unlike in the case of termination, motive is relevant, and the reason for which the employer abruptly brings the contract of employment to an end must be stated and justified. See Abomeli versus NRC. See also Savannah Bank of Nigeria versus Fokoku. It is for the employer to prove that reason is sufficient to warrant dismissal. See Ogunsami versus CF Furniture West Africa Company Limited. See also Nwabani versus Golden Guinea. See also Nwabani versus Golden Guinea. In any event, summary dismissal is a strong disciplinary measure to be justified in the most exceptional circumstances. It is one thing to have a reason to discipline and dismiss, and another to justify the reason. See Jupiter General Insurance Company versus Shroff. As pointed out earlier, dismissal is usually attributable to acts of misconduct. There exists a myriad of acts of misconduct that could be cited, but their justification must depend on the gravity or weight of the particular act of misconduct issue. Dismissal must be shown to flow from not just from the misconduct not this means it is not every act of misconduct on part of employees that suffice to have the employee dismissed. See Nicol versus ECN. See also CCB Nigeria Limited versus Wanko. But it is sufficient if the conduct of an employee is one of grave and weighty character as to undermine the relationship of confidence The reasons given in Exhibit T are the reason for dismissal of the claimant. Therefore, the onus of proving the reasons falls squarely on the shoulders of the defendant to satisfactorily prove or justify it. The law is that an employer has the right to dismiss an employee even if not specifically written in the written contract of service. See Simon versus Anasebe. See Simon Anasebe versus Bank of the North Limited. And the case of Zidel versus River State Civil Service Commission. This means the argument of counsel for the claimant that the employee handbook Exhibit J did not stipulate any of the reasons given by this means the argument of counsel for the claimant that the employee handbook did not stipulate any of the reasons given by the defendant for imposing punishment of dismissal, and as such, his dismissal on that ground is illegal, unlawful, null and void, cannot be the correct position in the face of the case law. The defendant has the right to dismiss whether or not the contract of service states so. All that is required is for the claimant to be afforded opportunity of hearing and making his defense for the alleged misconduct, and the employer must, by his conduct in issue, being guilty of a fundamental breach of his duty under the contract of employment. It must be such a breach as to amount to wrongful repudiation by him of the contract, thereby justifying his dismissal by the employer. In such situation, dismissal flows from the circumstances of discipline, which make it natural course once justified that the employee is not entitled to any benefit whatsoever, including notice, however, the law is well settled that the court may declare the dismissal of an employee null and void only in some rare cases. For instance, where the employment is protected by statute in the sense that the method of discipline is strictly regulated by statutory rules and procedure. In other words, if one party has purported to terminate the contract of employment, the court will grant such The court will grant a declaration that the contract subsists in special status or office by which a statutory regulation applies. For instance, the civil service rules of the Federal Public Service govern conditions of service of the Federal Public Servant, and it is made pursuant to powers conferred on the Federal Civil Service Commission by virtue of constitutional provisions. These rules have constitutional force and it invests the public servant with legal status which this means before special status or statutory labor can be invoked in favor of an employee, there must be clear evidence. Such evidence is derivable from the relevant statutory provision regarding the office or employment in question. Such status must be brought to the attention of the court, and the relevant provisions dealing with the employment must then be applied. If there is no such provisions, then there can be no legal basis in seeking a declaration that a transaction or dismissal is illegal, unlawful, null, and void. When an employment is not governed by any statutory provision, it does not enjoy any statutory protection, and a dismissal in such situation can only attract an employer in this circumstance is a liability to dismiss such an employee for misconduct. It is still within the right to dismiss such employee if it was satisfied that the employee has done something which is incompatible with the due or faithful discharge of his duty. See Western Nigerian Development Corporation versus Abimbola. See also Imolome versus West African Examination Council, WAEC. In the case at hand, there is no doubt the employment of the claimant has no any iota of statutory labor. It is an employment governed by the common law principles and the agreement of the parties, Exhibit B and J. Therefore, the employer has the right to dismiss the claimant in line with the agreement of the parties. Exhibit J, while which is the extant regulation governing the employment of the claimant, has made ample provisions for Exhibit J, which is the extant regulation governing employment of the claimant, has made ample provisions for discrimination and clause 5 and clause 10.6 of J have specified procedure before for dismissal of the employee of the defendant. By these rules, the defendant has the right to discipline its employee who breach any of its policies. By these rules, the defendant has the right to discipline his employee who breached any of its policies and appropriate sanction attached to it. Where an employee demonstrates unsatisfactory conduct that is inconsistent with his or her responsibilities or position, and therefore disruptive to the smooth working of the department or branch, or put the defendant's image or reputation as at risk, the disciplinary measure can be lawful against in any event. It is a question of circumstances and what particular act amount to misconduct. It is the facts as revealed from the evidence before the court that determine what particular act amount to misconduct. One common parameter has always been considering employees' conduct side by side his contractual, statutory, common law duties, but still it has remained a further question of what degree of breach that will suffice. In Nigeria, Arab Bank versus EA Shuaibu, the Court of Appeal cited in the Nigeria Arab Bank versus Shuaibu, the Court of Appeal, making reference to the scene Olorin Toba versus Naisa, Olatunbosun versus Naisa, held that under the common law and statute law, disobedience of lawful order from any servant, high or low, big or small, is viewed with seriousness. Such conduct normally and usually attracts the penalty of summary dismissal. Disobedience make disobedience ranks as one of the worst forms of misconduct in any establishment. The court further observes that there is no fixed rule of law defining the degree of misconduct that will justify dismissal. It is enough that the conduct of the servant employee is of grave and weighty character as to undermine the confidence which should exist between him and the master. The question that presently arises, therefore, is whether the defendant has justified the dismissal of the claimant, having given reason for the said dismissal. The combined effect of the amendments in paragraphs 5, 6, 7, 8, and 9 of the statement of defense is to the effect that the claimant leveraged on his knowledge of Mr. Michael Eke Ono and brought the society to the defendant to open account. upon to open account to open accounting, overlooking all risk factors that is a diligent and loyal employee would have guided against. And in addition to requirements listed in paragraph 10 of the statement of facts, the CBN has developed KYC, know your customer, a due diligence policy for compliance by banks. The claimant has, in the performance of his duties in processing opening account for the society, has failed to diligently do the KYC, which would have given the claimant hints on knowing the true color of the customer before opening the account. The claimant, on his part, insisted that all the requirements for opening account, for opening cooperative society account listed in the dependence account opening package were obtained from customers either at the point of account opening or were regularized later. The claimant has not breached any policy of the dependent. For KYC check is an ongoing affair as long as there is subsisting relationship between the dependent and the customer. The claimant stated further that in furtherance of check, he visited Obong of Calabar to confirm customers' claim and even obtain receipt of payment for purchase of land by the customer for legal by the customer. For legal search, it is the responsibility of customer service officer and legal department pending regularization of such documents. As it is the practice of the defendant, the claimant further stated that the claimant further stated that the due process check were followed in opening and managing of the society's account. The claimant further stated that the account can be opened and operated with outstanding documents, pending regularization of such document, as it is the practice of the defendant. The claimant further stated that due process checks were followed in opening and management of the society's account. In the conditions of service Exhibit J, one of the key tests for exceptional service is attention to details. An employee owes it a duty to his employer to take reasonable care and exercise due diligence in discharging of his duties. In Nigeria Arab Bank versus Shuaibu Sufra, the Court of Appeal held that measuring up to standard of an employee measuring up to standard of an employee is not confined to employees' efficiency at work. It includes a commitment to safeguarding the interest of the employer, reasonably minimize financial losses, and maintain the reputation and goodwill of the establishment. In Abomeli versus NRC Sufra, the Court of Appeal stated that once an employee is studied and there is lack of diligence in his approach to his duty, or he is negligent and the master by the same suffers loss to the unacceptable and untoward behavior loss. Such employee is guilty of misconduct for which necessary disciplinary action can be taken against him. Applying the principle of law enunciated in the above cases and just supporting them with the facts of this case, it shows facts of this case are shown by the pleadings and evidence before the court. I have no doubt in my mind that the claimant in this case was not diligent in carrying out his duties in respect of the role he played in processing opening of account for the society. Although the claimant has insisted that he followed due process, the evidence adduced by him contradicted his claim, as Exhibit EFU clearly shows that the claimant did not follow due process in opening account for the society. In paragraph 8 of the statement of facts, the claimant admitted opening account for the society in the course of his official duties. And in paragraph 9 of the statement of fact, he stated that the account opening package requirements for societies, clubs, and associations, Exhibit U, have 12 conditions which must be fulfilled before a multi-purpose cooperative society account will be allowed to be opened. Will be allowed to open and operate an account with the defendant. The 12 conditions were enumerated in paragraph 10 of the statement of fact. It is clear that Exhibit N, the certificate of registration, was issued pursuant to a Cooperative Society Act 2004, Cap 98 laws of the Federation 2004, while the combined reading of Exhibit E and F, which represent the bylaws of the society, of the society and certificate of registration of the bylaw clearly shows that there was no bylaws constitution of the society registered as per exhibit N. This is apparent from the address on the bylaws and the exhibit F, which explicitly stated that in its certificate of registration of bylaw made pursuant to Cross River State Cooperative Society Law Cooperative Society Law of 2004. I shall also observe here that Exhibit E and F were one and the same document, but counsel for the claimant separated them and tendered them separately as if they are not one and the same thing. This can be verified by looking at Exhibit E, which has pages 1 to 23, and Exhibit F, which has page 24, which has the number 54. I do not know why council decided to remove Exhibit F, Exhibit E. And tendered the separate. This is an attempt for the council to confuse the court. Also, council failed in this attempt. With the above analysis, it is clear to me that evidence abound to establish that the claimant often account with incomplete documentation. The claimant, while making reference to Exhibit D, has agreed that an account can be opened with incomplete documentation as it is practiced by the bank. I do not subscribe to the contention of counsel as Exhibit D is not capable of establishing practice of the defendant for opening of account with incomplete document. The reason being that Exhibit D is the auditor's query to his finding regarding the accounts open for a particular period of time. For a particular period of time, indicating that the opening of the account was defective due to what he has observed and noticed. The facts remain that up to the time of writing this judgment, the bylaws or constitution of the society, which was registered as per Exhibit N, has not been produced or submitted to the defendant and remain outstanding. The finding on Exhibit E and F also goes to show that the claimant did not do proper KYC on the society. As the claimant was blindfolded by his knowledge of the alter ego of the society. Of the alter ego of the society, which led him to compromise on the standard required on him in performance of his duties to the defendant, which led him to compromise on the standard required on him in the performance of his duties to the defendant, which he himself stated to be mandatory in paragraph 8 of the Statement of Facts. Exhibit D1 to 5 and D4 to 17 are clear proof that the opening of account for the society with the defendant has facilitated some members of general public to lose their money lodged in the account of the society, which is the defendant were eventually which the money were eventually diverted to individuals' accounts with other banks, which the claimant described as agents of the society, who are to carry out the project being undertaken by Micheno, by the society. This piece of evidence is hearsay, has no any evidential value, as the claimant, not being a member or subscriber of the society, does not have the capacity of giving such evidence, as such evidence is not within his knowledge. Exhibit 4.1 to 7 support the claim of the defendant that the society birth in Calabar with all the distinctive features and paraphernalia of a signature Tom Ponzi and promising depositors interest at the end of 40 days for their deposit, which entice people to subscribe to subscribe and lodge their hard-earned money to lodge their hard-earned money into accounts of the society with the defendant, which were later diverted. the reasons given by the claimant as purpose I am fortified in my belief that the story of the defendant that the account was set up for Ponzi and dubious activities as support in the failure of the claimant to convince the court that the society is undertaking any estate development in Calabar as per his claim. Therefore, the claim that the lodgement in the account of the society is for estate development is not true and not proved. The reason being that the claimant as the reason being that the claim of the claimant that the purpose of the society was for estate development for development of land which belongs to Michano Ventures is not acceptable to the court. As he said, as the purported evidence of the purchase of the land clearly shows that the land does not belong to the society to which the account was opened or to which the account belongs to. Therefore, the lodgement cannot be said to be for purposes of development of estate, which was purchased by the receipt tendered by the claimant. From the foregoing, I firmly believe that the defendant has proved reasons given for dismissal of the claimant from its service. The claimant has also argued that there is nowhere in Exhibit J where reasons given for dismissal as per Exhibit T were listed. I have had a hard look at the entire content of Exhibit J. I am satisfied that there are ample provisions in Exhibit J that covers or deals with the situation at hand. See clause 9.2 of chapter 9 of the exhibit J. See also item 17 of the table at page 47 of exhibit J. See also item 2 on negligence leading to loss at page 48 of exhibit J. These provisions are clear enough to cover the actions taken by the defendant. I came to my conclusion, notwithstanding the stance taken by the claimant that the reason for dismissal was not contained in Exhibit J, the claimant should not demand or expect that the defendant must quote verbatim from Exhibit J for reasons for dismissal. What is important is, has the facts disclosed establish any ground? Disclose any grounds for dismissal? If yes, the action cannot be faulted because the defendant cannot be faulted because the defendant failed to state verbatim or quote from Exhibit T that the dismissal is pursuant to a specific clause in the Exhibit J. I am satisfied from the facts. The facts have established gross misconduct against the defendant in that he often account with incomplete documentation, which led the opening of the account with incomplete documentation and operation of the account has led to the eventual defraudment of the people that lodge money into the said account. The claimant dismissal is within the purview of Exhibit J, and therefore the dismissal was proper. The claimant has also, in answer to the query issued to him as per Exhibit V, stated that according to information gathered during marketing drive, the main purpose of the cooperative society was for estate establishment. I have scrutinized all the processes and documents before the court and could not lay my hand on credible evidence establishing the assertion of the claimant. Rather, the document tendered by him goes against his submissions. Exhibit S, which claimant relied heavily in proof of establishing the assertion that the main purpose of Michano Multipurpose Cooperative Society is estate development, cannot in any way establish that assertion for the simple reason that Exhibit S is evidence to show one Michano Ventures purchased land from a community and not that it was purchased by the society that has account with the defendant. It is not capable of establishing any purchase of hectares of land by the society in Calabar for estate development. Even Exhibit E, the purported bylaws, does not have provisions for estate development. There are so many clues in the documents tendered by the claimant for him to smell foul, but decided to negligently treat them with disdain due to his knowledge of the promoter of the society. From all I have been saying above, the defendant has, by the evidence before the court, shown justification for dismissal of the claimant from its service. Therefore, the claimant failed in its bid to have his dismissal reversed. The defendant, having complied with the law in taking disciplinary action against the claimant, the The claimant has also stated that his dismissal to be premature because the committee that investigated him, as per XBD W3125, has stated that the dismissal should be after investigation by a regulatory authority. Exhibit D1, 1 to 7, tendered without objection, clearly shows that the regulatory authority has investigated the matter and has indicated the matter and apportioned blame appropriately. On the whole, I am satisfied that the defendant has proved the reasons as contained in the letter of dismissal, and the claimant has no any reason to complain about the action taken by the defendant to safeguard his reputation from being damaged. I so find and hold, and the claim of the claimant, having been found to be not meritorious, is hereby dismissed. Judgment on the counterclaim. The law is without any equivocation that the counterclaim is an independent action from the substantive suit. Like every other civil case, the person who asserts has the burden of proof. The counterclaim of the defendant claimant to counterclaim is as stated in the statement of defense as indebtedness to it by the claimant, the defendant to counterclaimant. For the defendant claimant to counterclaim to succeed, it must prove its assertion by adducing credible evidence. In other words, a counterclaim is to be treated for all purposes for which justice requires it to be treated as an independent action. See Ogbonna versus Attorney General Imo State. The right of action by way of counterclaim can only be exercised by the service of a pleading embodying the counterclaim or of some other document which the court orders to stand as pleading. Thus, a counterclaim is made when it is properly formulated and the facts in its support duly pleaded to support the reliefs being sought by it. In other words, a counterclaim is not pleaded by merely pleading the reliefs being sought without actually pleading the relevant materials fact to support the reliefs. The relevant material fact to support the reliefs being claimed in the counterclaim, such as document evidencing indebtedness of the claimant to the defendant, counterclaimant, have not been made available to the court. In fact, all the relevant facts which ought to have been pleaded and established by evidence before the court could consider whether or not the relief sought in the counterclaim have been proved, has not been supplied to the court. In the circumstances, the counterclaims fails for lack of proof, and same is hereby also refused. The cumulative effect of my findings on the substantive claim of the claimant and the counterclaim of the defendant is that both the claimant and the defendant have waived to prove their respective cases to warrant granting any reliefs in their favor. Therefore, both the claimant's claim, and the defendant's counterclaims are hereby dismissed for lacking in merit. I make no order as to cause judgment is entered accordingly. You are welcome. Yeah, you are welcome. There is nobody online. I have not seen. Okay, let me see.
My Lord.
Yes, call the case. Number NICNCA 63/2020 between 1, the Ababo Investment Limited, A Oil. 2, IT Basi, Tuntun Basi. And 1, Ipa Steel Nigeria Limited. Ipa Steel Nigeria Limited. 2, Mr. Yes, 3, Mr. Sanja Manda. 4, Mr. Bishop is Soldier. My Lord, the second claimant of record is present, first absent, defendants are all absent. Second claimant in court? Yes, my Lord. Appearance?
My Lord.
Yes. Adam Duke. Yes. Yes. Any appearance? Appearance for the defendant?
Respectfully, my Lord.
Yes.
Lai Babatunde SAN.
Lai Babatunde SAN.
Yes, my Lord. Lai Babatunde SAN appears for the defendants. My learned friend, Tolani Lai Babatunde. Lai Babatunde is a compound name now, sir.
With Polami Babatunde?
Tolani Lai Babatunde, my Lord.
Polami Lai Babatunde?
Yes, with an hyphen this time around, sir.
Yes.
Appear for the defendants.
Yes.
Well, my Lord, I was part of the proceedings whereby your Lordship just gave a judgment. I must say that with utmost respect, I want to commend your Lordship for a very detailed judgment.
Thank you very much.
Usually, we lawyers are very happy, irrespective of the outcome. Where judgments are so detailed and so balanced. I want to thank your Lordship on behalf of those of us at the back, and also wish your Lordship a happy New Year.
Thank you very much. I wish you, sir.
Thank you, sir. My Lord, we got information that this matter came up sometime last week. As at that time, we did not have any. On
12th of January.
Sorry, my Lord.
I say it came up on 12th of January.
Yes, on the 12th of January, my Lord. We did not have notice of that date that the matter was coming up.
That was the reason why I adjourned it to today. When I look at I asked for proof of service. When they could not provide it to me, I said that I can't hear it until when I have proof of service.
I'm most grateful to your Lordship, sir. So we got information. The registrar was kind enough to inform us that the matter came up and that it was adjourned to today.
Yes.
And that when it came up, there was a motion or notice that the court was going to consider filed.
Yes, there is an motion for interlocutory injunction.
Yes, my Lord. So that motion, my Lord, that motion was scanned to us on Friday. It was scanned to us by the registrar on Friday last week.
Okay.
So we struggled very hard over the weekend, sir, to prepare our papers and file them yesterday.
Okay.
If I may identify what you have filed, sir,
Yes.
to be sure that your lordship is in possession of those documents. We have filed the counter affidavit opposing the application. Yes, my lord, opposing the application for injunction. The counter affidavit is the counter affidavit is sworn to by Mr. Rajesh Saraf.
Mr. Rajesh Saraf.
Yes, Mr. Rajesh Saraf.
Yes.
And it was sworn to on the 16th day of January 2023.
Yes.
My lord, we also filed an application. We filed a motion on notice.
Yes.
Also on the same date, in which we have raised the issue of the jurisdiction of this honorable court to hear and determine this matter.
Have the processes been served on the claimants?
My lord, I believe that we also just in the same manner that we scanned the processes to your lordship, to the court, we also forwarded it to counsel for the claimant. I believe that he will be in a position to confirm, sir, whether.
Yes, Mr. Ayo, have you been served with the processes that they filed? But counsel said that he has scanned you. Well,
my lord, I cannot hear the learned counsel, sir.
The learned counsel is saying that he has not received any document from you. That if you have scanned them, he has not seen them.
They were scanned and sent at the same time that the one to the registry was sent, sir.
Mr. Ayo, you
on the 2nd day of January, my friend said
yes. And now they have filed counter affidavits. They have filed on notice challenging the jurisdiction of this court to hear this matter. That is the present position. So what do we do? Learner 6.
Yes, my lord.
He said he has not gotten the service. So please ensure service after we finish today's sitting. Ensure that the counsel for the claimant is properly served.
My lord, we will do that even if it means doing it physically.
It's all right. So, Mr. A, on the pace of having regard to the processes now before me, do you think we can proceed today? I'm not doubting you. I did not say you have received, but the court has them, has the process. The court has the motion on notice. Go and show him, which he has filed at our registry in Lagos. You know, our rules allowed us to file anywhere. So, no, they will serve you. They will serve you. So what do we do now? With the state of the matter before me now, what do we do? Hey, you know, Mr. Ayo, you are already before the court now, and the court is seized with the matter. So I believe no one among the parties will do anything that will jeopardize the hearing of this case. And if anybody did anything, the law will take its course on him. So don't have any fear that your clients are this and that. The issue now is they are now raising the jurisdiction of this court, and you know it is the law. Once the issue of jurisdiction is raised, it has to be resolved.
As the court pleases.
Registrar.
Yes.
Let me see how is our program next week, if we can accommodate them. Huh?
17th, is it? Yes,
Monday. I'm sure these cases will go on this NSIT here. You have to find a date for them next week, so that because of the urgency, don't want. Saturday, Sunday, on the 30th. We can accommodate this to them on Tuesday now, 24. Lanesik.
Yes, my lord.
Yes, I will adjourn the case to 24th of this month for hearing.
Well, my
So
lord,
that we can hear all the. Yes.
My lord, may I respectfully, sir, if Monday, my lord, the 23rd will be convenient for your lordship.
Mr. Ayo, is it convenient for you Monday? Okay, Monday 23rd.
Monday 20.
By consent of counsel, this case is hereby adjourned to 23rd day of January 2023 for hearing of preliminary objection.
As the court pleases.
Is it virtual or physical?
Well,
Nancy, are you coming physically?
well, my lord, 23rd of well, we might as well come physically, sir.
Okay, anyone you people agreed on.
I think if your lordships, or for instance, the court is physical and both virtual today. So if your lordship gives us the option, we can take advantage of either of the
Okay.
And then we can also make it virtual, sir.
Okay. This matter will be heard virtually.
As a court pleases.
Okay, thank you. Call the next case. Thank you, Nale 6.
I'm most grateful, sir.
You are welcome.
Number NRCMC 01 2020 between Mr. Oka Michael and one Cross River State Institute of Technology and Management.
Where is it?
Government of Sunland.
Okay.
As for the General Commissioner for Justice, I don't have
Appearance?
my police, my law.
Yes. Patrick Open.
My appearance is for them.
Yes. Any other appearance? Yes. Yes. UDE NYI Omaji. Yes. Likom Akwe. Yes. Yes. Have you filed your addresses? Okay. Have you submitted on the other council? Mr. Opem, are you objecting? Is it? But you heard when she said she has application for extension of time. If you know you have any issue, you stood and raise the issue. Mr. Open, this is reply on point of law. What are you objecting in it?
And prepare their authorities to do that administration. We have to face the road and we have to pay only for us to be a surprise.
Don't worry, we will give you adjournment to go and prepare. Okay. Okay. Are you objecting to the application, Mr. Open?
We have no
The application is granted as spread. So what do you want, Mr. Okay. It's all right. It's all right. Hey, come. Where is the? This one is for who? Where is the soft copy of the defender? Where? Okay, this is not the file. Okay. It's all right. Give me that for adoption. No. This case is hereby adjourned to 2nd of February 2022 for adoption of final written addresses. What's the next case? Huh? Okay.